So next on our agenda is CTPC member Sharon Treat giving us an update. I already kind of started a little bit in the update.
A little bit, but I'm going to start first with the TransPacific Partnership. And, you know, the big, it's kind of funny, I kept sending Locke these articles, and one would say, the text is going to be released on Friday, and then there'd be another one that say, text is going to be released, you know, in 2 weeks, or then another one, text may not be released until, you know, sometime in November. And so, you know, there's a lot of desire to have the text to be released, but I think one of the things, and I think this is important for the commission in terms of if we're going to schedule a public hearing on the TPP, it really needs to be after, I think, the text has been public for at least 30 days, it would seem to me, if that's possible, because you can't really analyze it in, you know, a day. And we don't know when it's going to be released. And I just wanted to give a little background based on my reading all of these different articles. I cannot tell you when it will be, but I do know that, you know, it has to go, each of the, there's 12 different countries, and I believe there's 3 different official languages that the text needs to be translated into. So when you think about a work session where you get everybody to agree to a text, and then you have to translate it, and there's different ways that things can be translated. I've read books that were translated that didn't seem to bear much relationship sometimes to the English version. You have to make sure that everybody buys into the translation actually being accurate. And there's also something they call legal scrubbing. And so that is going on right now. And some of that, I did have some, so they can't release it. I mean, Stephen Harper, who just lost his election in Canada, who's the prime minister there, you know, promised that he would release the text before the election. Well, that just wasn't going to happen, and it didn't happen. And so, you know, we really don't know when it's going to be, and, you know, I think there's an interest in having that happen within the next 2 weeks or so, but I just would say don't hold your breath, because it's, the reality is you've got to get each of these 12 countries to sign off on, this is the text that we want the public to read, and they don't want to have words in there or phrases in there that aren't what they think they agreed to. So that's the reality there. And the other thing is that apparently there's many side agreements, like between 2 different countries. So between the US and Japan, apparently there's something like 12 or more different side letters that say, well, with respect to rice, we're going to do this, do we understand blah, 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 or respect to that. Well, all of those side agreements, and then there might be some between Japan and Chile, and then between Chile and Peru, and between Peru and the US. So those all have to be translated, and, you know, whether they're going to be released at the same time as the text, I don't know. So I just wanted to kind of lay that out. And then secondly, we've been very focused on, well, fast track and the US consideration. Now, basically Congress is, under the fast track rules, gets to look at the text for 30 days before it goes public. And then there's going to be at least a 2-month period when it's public before it could be voted on by Congress. But that doesn't mean that it will be voted on in 90 days after it's given to Congress. And particularly now when, you know, we have Congress, the House in particular, without us, maybe they're voting today, I don't know when the vote on speaker is, but they haven't, you know, legislators and former legislators know that you can have a dysfunctional legislature with a speaker, but you're sure to have it without a speaker. And so to be able to say that they're going to take it up in short order when something is very controversial, it's really hard to predict. So some of the predictions are that it wouldn't actually be voted on until a lame duck session after the 2016 elections. Then again, I just saw on my email moments ago, the administration is saying that they're confident that they will work out a window with Congress to have it taken up, you know, promptly. So it's really, you know, anyone's guess, and I think anyone who says that they know all about it, you know, you should probably take it with a grain of salt. The other thing is that in addition to the U.S. having to agree to it, you have 11 other countries. And so I was looking at an article that kind of went through this, and it says Brunei, it's for the Sultan to decide. Okay, that's one of the countries that we are, in this relationship with. The Sultan gets to decide 100% whether it happens. Vietnam, it says approval could take 18 months to 2 years. Chile, some opposition, no clear timetable. Malaysia, PAC will probably come up in 2016. Well, what does this mean? Can the TPP go into effect if the U.S. approves it, but some of these other states are out there? Well, part of the rules of the TPP were that, and this was a proposal that came from Japan, it said that, well, and I don't know if it's the economies or the population, maybe there's others in the audience who know, but the proposal was it goes into force even if all of the countries haven't ratified it, when I believe 85% of the population is, and maybe it's the economies, I'm just not sure, has agreed to it. Well, basically, the bottom line is, the deal was, if Japan, Canada, and the U.S. all agree to it, then it's going to go into force. That's the bottom line of what those rules mean. But part of the whole TPP is that, one of the ways they come up with compromise is to say that certain provisions won't go into effect over a long period of time. So let's talk about footwear, which I still haven't gotten an answer about whether or not the tariffs, what's happened on the tariffs, even though I'm cleared advisor, but I'm still trying to find that out. But one of the ways that the USTR has tried to soften the blow in other situations is to say, well, the tariffs will go down to 0, but it will take a certain period of time, a number of years. And so there are going to be many, many provisions of this TPP that even if it goes into effect after you have the 85% that ratify it, those provisions still won't go into effect for a number of years. And so, for example, one of the areas where there was a lot of debate, a lot of controversy, and in fact the final issue to be decided had to do with prescription drugs and the new expensive biologics becoming generic versions or biosimilars. And some of the countries did not have the same rules as the U.S., and they have a especially long time period to come into compliance with what was negotiated in the agreement. So it could be a 10-year period for some of them before it actually goes into effect. So that's just sort of, some of the atmosphere around it. And I guess I would just encourage the commission I guess we have to have another public hearing before the end of the year.
Yes.
So that may be a constraint, but it might make more sense to schedule that, say, in December than in November. And just to put that in, in terms of what's in the TPP, I haven't been able to read the final agreement. I believe that there will be an opportunity for me to look at that, perhaps before it's public. Because I serve on an advisory committee. There's also going to be a lot of discussion and negotiation with members of Congress. There's heavy-duty lobbying going on right now already. But in the past, there have been some negotiated side agreements with Congress that have made passage more smooth for past agreements. And I guess what I would put out there about that is that that's far less likely to happen in the case of the TPP, where you have 12 countries that have to agree to anything. If you have a bilateral agreement, 2 countries goes to Congress, Congress says, well, we're not going to accept it unless you do something, say, on currency. It goes back to the other countries, there's only 2 of them to decide. But if you're looking at the TPP with 12 countries, then that kind of additional agreement, if Congress wants to try to change something, is highly unlikely. And there's been a lot of people, both from other countries and also top people in the U.S. and USTR saying, that's not going to happen, so if you think it is and you're pinning your hopes on that, just get over it, because this agreement is as is, and that's the way it is. So I just, put that out there, and there is certainly controversy about much of it. Seafood safety, food safety is a huge issue. And it goes in all directions. There's people that say it goes way too far in terms of making drugs more expensive. There's others, including Orrin Hatch, who's an influential, chair of the committee, saying it doesn't go far enough, and, you've sold us down the river, the pharmaceutical industry has been sold down the river, and it just, doesn't go far enough, and I don't know whether I can support it. So, we'll have to see whether some of these statements are kind of posturing, or whether they in fact are meaningful. And of course, with presidential politics, not only in the US, but in a number of these countries, and we already see candidates on both parties here in the US, taking positions on the TPP, both against and for, and that, of course, can be a factor in terms of what happens ultimately. So.
Regarding pharmaceuticals, is it going to change the chain of custody with the FDA? I mean, is that what you're talking about?
No, it's really focused on the big issue that the agreement came down to was you have a period where if you have a new product, a drug, you have a monopoly on it. It's a brand name. It's like 25 years, I think. It's a long period of time. And then it can go to be a generic, except that there's something called data exclusivity, which adds an additional period on top of the monopoly period, where it says that another company can't make a generic version of this using your data where you had your clinical trials. They have to go out and do their own clinical trials, which is very, very expensive. And some people feel it's unethical because you're subjecting people to tests that you don't need to because it's already been proved to be safe or at least effective. So the big issue, one of the big issues in the TransPacific Partnership that prevented it from coming to agreement for a very long period of time was this issue around data exclusivity, which basically adds on an additional period of time on top of the patent period when you have a monopoly. And particularly the issue was for these new biologic drugs, which not only are huge lifesavers and very, very important that way, but are also extremely expensive. So there were 5 countries that were part of the TPP that did not have any rules around data exclusivity at all, no additional period over the normal monopoly period, patent period for these biologics. And the U.S. was trying to get 12 years, which is in U.S. law, although interestingly, we have budgets that say it's only 7 years. So, it's kind of a mushy position. And so the final agreement actually came down to a fight over this because many of the countries that did not have this extra period were extremely concerned that if they added it on, it would delay moving the drugs to generics and cheaper versions, and that this was going to basically cause people to die because they weren't going to be able to get the medications at an affordable price. And also, of course, many countries like the U.S. also purchase drugs themselves, and so it's a budget item. So that's the drug issue. And, we do know that there is, the other issue that we've gotten involved in the commission is whether or not there's rules that say you can't bargain drug prices as part of your health programs. And there is new language on that. It was toned down. Again, as a cleared advisor, I still haven't been allowed to read that language. So, I'm somewhat frustrated because I can't really say whether it's adequate. But what had been floated publicly was that it did actually restrict Medicare in some ways from some of the price negotiation that might want to be done in the future around Part D, which is, of course, a very important part of the prescription drug program for older people.
Thank you, Madam Chair. Sharon, how is the agreement going to affect importation of drugs like CanRx? We've been dealing with that, and FDA says, that drugs have to be safe in order to be imported and whatever. Well, are they all going to go by the same rules when it comes to, like, for example, Nexium sold in the United States is now a generic, well, over the counter. But there are some that are still proprietary, but will they be able to be imported into this country from a country that's getting him much cheaper than what we are paying for him? Is that part of what's going on too?
No, I don't think so. I don't think it relates to, imports of drugs specifically. I mean, I think that there are some sections of the TPP that are focused on protocols for production of drugs, so that there's agreement across different countries about whether or not something is an adequate manufacturing process for a drug. But in terms of importing from Canada, I mean, the way I look at that, and I've been in favor of importing from Canada because it's a way of bringing prices down, but it's, what we're really importing is their price controls, pretty much. I mean, that's the issue, because we haven't had the wherewithal within our own country to make the decision to have price controls. So we're having them sent over from the border because Canada has done that. So, but this agreement doesn't, I don't think, make any particular changes in the rules that the FDA has applied in the past.
I have one more question.
Yep.
Sharon, talking about country of origin, branding, labeling, whatever, there's nothing, if that does go into effect, there's nothing to say that a Maine potato can't be grown in China and sent over here as a Maine potato, or vice versa. Will we be able to market a Maine blueberry or a Maine lobster or a Maine potato if other countries can send them over with that same classification? It goes both ways. Are we going to be able to market it even though other countries could possibly send it to us that way?
Well, I think this is one of those areas where we're going to need to really read the text. Certainly, there's issues around labeling under the WTO, and we're bound by that already. So the TPP and also the Atlantic Agreement are intended to be WTO plus, which means they go beyond the WTO. And I think we're going to need to look at how they go beyond. The U.S., it gets very confusing here, but and I don't know how the TPP deals with this as much. I know that in the European Union, they have this very established system of these geographic indicators that they put into treaties, okay? So they have an agreement with this other country, and they say, you cannot call it champagne when you make it in Spain. It's got to be from Champagne, France, okay? And that's the system they have to maintain the integrity of these products, and it's long-standing, but they put it into their trade agreements. The U.S., and again, I'm not an expert on this, but the U.S. has traditionally relied on copyright law, intellectual property law. So you take out a copyright on the term Maine lobster, okay? And it's enforced through copyright law. So the question is, what happens when these two different legal mechanisms come together? And so I don't know what was negotiated in the TPP around that, but I do know, I've been doing some research around the labeling issue, and I think that there are some concerns about what may be in the TransPacific Partnership around labeling. And there's a whole section that's called technical barriers to trade. I know you may remember Locke reading from the U.S. document complaining about other countries' technical barriers to trade and mentioning that they sounded an awful lot like the rules and regulations that we've adopted in the U.S., and that is in fact in the case. So there are other provisions, and technical barriers to trade actually gets into things like, what you can put onto labels and whether they're discriminatory or not. So again, it may take a trade lawyer looking at this stuff, and sometimes you don't know until someone challenges what you do, and it goes to either the investment, the arbitration panel between countries, or from a company suing a country. But sometimes you don't know what the rules are until you go before the arbitration panel, and then they tell you, oh yeah, you're in violation. So again, that's why having the text itself is so incredibly important, and I think that we need to, as a commission, do our best to try to understand it, because we may want to take a position at some point about the TPP. I mean, there's going to be good with it, and there's going to be bad. I mean, there's going to be things that hurt our state and that hurt our businesses, and there are going to be things that help. for example, if the tariffs come down on lobster by 20% or whatever, that's going to be very helpful to lobster. On the other hand, if they can't market it as Maine lobster, that might be a problem. So these are things that we're going to have to look at, and hopefully we'll have time to actually do it based on real language this time, which hasn't been the case in the past.
Right, so,
Well, if I could just say very quickly, investor-state dispute system is a system where corporate investors, foreign investors, can sue a country, generally to challenge a rule or regulation or standard as being an expropriation, taking their property. It's very similar to, say, the takes clause of the U.S. Constitution. And they can go to this arbitration panel, which has 3 attorneys, not judges, who then rule on whether or not the regulation in question, which could be anything from a regulation saying, Maine lobster is X, and it will be labeled as Y. That could be the regulation. I mean, it could be anything. And then they say, well, we want to get X million dollars because our lobster is being disadvantaged by this label on the Maine lobster, and we've lost X amount of money from our company for whatever it is, and that's a taking, essentially, and so we want you to compensate us for that. And generally what happens is there's compensation if they win the case, and also often the regulation goes away as well because nobody else wants to pay the money going forward. So tobacco has been a particular subject of these cases. There have been cases in Uruguay and in Australia and in some other countries, I believe, challenging tobacco regulations that are health and safety regulations, packaging, labeling regulations, safety warning regulations on tobacco packaging, saying that they violate trade rules and that the countries that have passed these laws owe Philip Morris and other giant tobacco companies millions and billions for reducing how many cigarettes they can sell. And those cases are ongoing right now, and so the attorneys general in particular of the U.S. states have taken an interest in this. They care a lot about other things that ISDS could be used to challenge, but they have particularly focused on the tobacco because in the United States, our federal tobacco regulations are because 46 state attorneys general brought a class action lawsuit against the tobacco industry, and through that lawsuit got the authority to impose on the tobacco industry all kinds of rules and regulations about not marketing to children, et cetera, et cetera. And so when the FDA finally decided to exercise, and Congress gave them more authority to exercise regulating tobacco, the states maintained their very strong role in regulating tobacco, and then the FDA, Food and Drug Administration, also got additional authority. So the AGs have been particularly protective of, wanting to maintain their authority to regulate and to protect the public health through these tobacco regulations. And so they've worked very hard to get this carve-out. Carve-out meaning that you remove the subject either from the whole agreement, which is what they wanted, or what apparently has been negotiated, but no one sees the language, from a company being able to use this investor-state private dispute mechanism to challenge a country's regulations. And what we don't know, and sometimes the devil is in the details, how comprehensive is that? Is it truly saying you just can't challenge these tobacco rules or not? And right now, all we have are descriptions about it. We don't really have the language. So that will be something that I would think the commission would want to look at and have conversations with their attorney general about what her view of it is. But it is an area where, if I could say, the advocacy by the Maine Trade Policy Commission, among other state advocates, has, I think, made a difference, actually, in the outcome of what's in this agreement. So I think that the Trade Commission could perhaps, when we write our annual report, that might be something to put in and just say, this is something that the commission has been advocating for like the last 5 to 10 years. And it appears that finally, some attention has been paid to that issue.